I'm a member of the YouTube generation, so I take myself doing everything. Good afternoon. Professor Dory and I have been asked to say a few words about unpaid internships in Ontario. Well, we're going to split up the talk into three distinct parts. First, I'm going to run through a brief introduction to the topic of internships and then explain the law in Ontario. Then Professor Dory will run through how to structure a lesson plan to teach students about unpaid internships. After Professor Dory is done speaking, we set aside some time for questions and discussions, as both of us would love to hear your perspective on the issue and answer any questions that you may have. So throughout this talk, I'm going to frame this issue as one that very much implicates serious questions about the current state of public policy vis-a-vis post-secondary education in Canada and Canada's youth labour market. At the core are society's approach to unpaid internships, and the school-to-labour market transition is a good bellwether for how we approach public policy towards these and intergenerational equity. I want to unequivocally state that there's no question that internships are an incredibly valuable tool in bridging students in the school-to-labour market transition. And no one really disputes the benefits of the internship model. That being said, unpaid internships are quite problematic with deep economic, social, and political impacts. And we're going to explore this through both of our talks. So to begin, I'm going to go over the rise of intern culture in North America and focus on some of the impacts. So where did internships come from? Internships first emerged as a form of job training in North America during the late 1800s. They were adapted from German medical education and popularized in North America by Sir William Osler, the famed Canadian doctor and medical educator, while he was a professor at McGill University and Johns Hopkins. Internships bear a direct lineage to the apprenticeships used for hundreds of years by the craft guilds in Europe. And they were eventually imported to North America during the period of colonization. Internships remained mainly a phenomena of the medical profession until the middle of the 20th century, when this form of training started to gain prominence in high-status industries such as politics, advertising, public administration, and many other fields. I saw one example this morning of the NFB, the National Film Board, doing a film internship in the 1940s. So internships of this era provided mainly white males with an intensive period of training, which often led to entry into well-paying permanent jobs. So what are internships? There's no standard definition of what an internship is. I'm sorry if you were hoping for one. It can describe anything ranging from an informal job shadowing lasting a few days to an entry-level contract position lasting a year or more. Ross Perlin, the author of Internation, a book that I highly recommend, states that the very significance of the word intern lies in its ambiguity. It represents a broader concept and sends out more targeted social signals than temp or freelance ever has. The definition that I'm most comfortable with is the following. Internships are a temporary form of employment for young people, which may be paid and might have an educational or training component to them. Unpaid internships, at the core, are pre-job, a form of pre-employment vetting that allows an employer and intern the chance to test drive a workplace or a career. It's a new form of employment for today's millennial generation. It's one observation that I've had. So the rise of the intern, how did it appear? So today's internships aren't like those of the past. While one can certainly still find examples of high-quality internships, The trend in the labor market points to the reality that internships are a form of precarious employment that's heavy on grunt work and light on training or education. The pay is often minimal or non-existent, the benefits are a rarity, and there's almost no job security. In the wake of the global financial crisis, many employers have used the bad economy as an excuse to cut labor costs and begin exploiting young workers via the use of unpaid labor. Within Ontario's labor market, there's been a troubling long-term trend towards precarious employment. This being jobs with low job security, little control over the conditions of work, negligible regulatory protection, and an income level that's well below the living wage. Examples of precarious employment abound, and there are temp agencies, short-term contracts, project-based work, and of course, internships. Over the past 10 years, we've seen an explosion of unpaid internships in the labor market, to the point where I've estimated that each year in Ontario there's approximately 100,000 illegal unpaid internships. This estimate is a separate figure from what I would estimate to be the hundreds of thousands of internships that students in Ontario complete every year as part of a formal education program. This could be co-ops or, since you all teachers, the placements that student teachers do in the Teachers College. So that's an example of a student internship. So let's examine briefly some of the impacts from internships. We're seeing the erosion of the entry-level positions and paid employees being replaced by unpaid interns. Unpaid internships have a direct impact on the economy through contributing to youth unemployment, driving down wages, slowing economic growth, and allowing employers to replace paid employees with unpaid ones. There's also a disturbing trend within unpaid work and unpaid internships with the exploitation of recent immigrants. So one point on this issue is that while my comments today very much focus on the youth angle, there's a separate narrative relating to employers using the unpaid labor of immigrants. And recently the Ontario Human Rights Commission addressed this issue in a policy on requiring Canadian experience from immigrants. So I don't want to frame this as one that's simply a youth issue. In a market economy that is predominantly consumer-driven, if you have a large chunk of the youth population forgoing wages for prolonged periods, you're going to start to see structural problems that impact demographic trends, such as household formation, house purchasing, birth rates, or boomerang kids. I'm sure some of you have boomerang kids. This has a direct impact on the wider economy. The rapid ascent of intern culture in Ontario isn't particularly a good development for anyone except employers who are obtaining a lot of free labor. We're at the point where unpaid internships can be found in almost any industry, with a high level of unpaid labor occurring in industries such as fashion, journalism, new media, law, social work, education, academia, health sciences, and public relations. There is a skew towards requiring unpaid labor from young workers in traditionally female-dominated professions, and at broader public sector employees such as hospitals, post-secondary institutions, and school boards. Again, I would point to the vast amount of labor that school boards obtain from student teachers and new graduates who are desperate to gain any sort of classroom experience. The reality is that young workers are providing billions of dollars a year in unpaid labor to employers in Ontario. Ontario is in a slow growth period and will be for the remainder of the decade. Eventually, we're going to see baby boomers start to retire en masse, but that won't be for a while. The real youth unemployment rate for the 15 to 24-year-old cohort sits at 20.9%, and we're seeing a lot of underemployment and unemployment and precarious work being pushed onto youth. A lot of the growth in the economy that we're seeing is in the service and retail sectors. But the wages in those sectors don't allow youth to build a life for themselves. It's a very hard scrabble existence. Unpaid internships also implicate a series of problems linked to socioeconomic class and social mobility. Students coming from historically marginalized populations and lower socioeconomic classes often don't have the ability to engage in unpaid labor. These barriers are an insidious problem that's leading to a creeping cultural apartheid that blocks students from entering high-status professions, such as law, finance, politics, journalism, that control Canada's socio-economic, social, and political levers. What we're seeing is students from wealthy families being rewarded with internship positions on the basis of their birth status, which erodes any semblance of a mediocrity. And the fact of the matter is that in certain professions, you do have to engage in a period of unpaid labor before you can obtain a paid position. Journalism is an example of that. So now we're going to move into an explanation of the law in Ontario. And it's somewhat complex, and I've broken it down into some parts, so it's more easily digestible, because it's a bit much. So what is and where does workplace law come from? We're going to start exploring the law with a simple explanation about where workplace law comes from. So in Canada, the legal system operates under the common law system, which we inherited from the United Kingdom. The regulation of employment in Canada is mainly a provincial responsibility rather than a federal one. Workplace law in Ontario comes from a variety of sources. And there's various aspects of workplace law that taken together form an overarching legal framework. Under the common law system, the legislature passes and enacts statutes which outlines the law in broad strokes, and they may enact technical regulations on a topic as well via orders from the cabinet. These laws then get interpreted by the courts, arbitrators, and administrative tribunals, which gives rise to case law and precedents. Case law, decisions arising from judges, arbitrators, and tribunal members, is an extremely important part of workplace law. These decisions interpret the laws and give a great deal of context to workplace law overall. So let's run through the different parts of workplace law. Labor law deals with labor relations in unionized environments. Employment law deals with interactions between employers and employees when there is no union and sets out a minimum floor of rights that all workers enjoy. Human rights laws address issues like harassment, discrimination, racism, and sexism. Workers' compensation laws provide for workers who have been injured on the job. Occupational health and safety laws protect workers from unsafe situations in the workplace. So Ontario has statutes in each of these areas, and these are the main sources of workplace law in Ontario. Some additional statutory sources for workplace law include the Canadian Charter of Rights and Freedoms, privacy laws, and the Constitution. Now, these laws don't explicitly speak to the issue of unpaid internships, but they're highly important statutes which have heavily impacted on the development of workplace law in Ontario and Canada. So, turning to employment standards and internships in Ontario. Ontario's workplace laws weren't designed to address the complexities of the 21st century labor market. Rather, our workplace law is rooted in the realities of Canada's economy in the early to mid-20th century, where workers enjoyed good wages, job securities, and families could be supported on one income. What we're seeing is a lot of governments, both domestically and internationally, being unprepared or unwilling to address the realities of precarious employment, and simply put, they're playing catch-up with the issue of unpaid internships. In Ontario, the Ministry of Labour and their political masters have done little to address the issue of unpaid internships, and in my opinion, it's having quite a detrimental impact on the overall economy. On a side note, earlier this year, I caught the parliamentary secretary to the Ministry of Labour. This is the second highest person in the Ministry of Labour advertising for an unpaid internship to help around her office at Queen's Park. So, the problem's running quite high. The law governing unpaid internships is contained in the Employment Standards Act 2000. This is commonly known as the ESA. This act contains the minimum floor of rights that workers enjoy, such as minimum wage, hours of work, vacation time, breaks, and the right to overtime pay. The ESA doesn't cover all types of workers. Some groups are excluded completely from the ESA or have certain rights restricted. So a few points need to be made about the ESA. This is a socially protective piece of law which was designed to give workers minimum rights in the workplace. The ESA contains two provisions critical to protecting interns and all workers, really. First, there's a prohibition on employers and employees from contracting out of the minimum provisions contained in the Act. This means that you can't undertake work for free in normal circumstances. This provision is in there so employers don't require employees to sign contracts that are lower than the minimum standards contained in the ESA. Second, there's a provision setting out that employees need to be paid an hourly minimum wage. So the dual legal narrative related to unpaid internships is one of wage theft. This is the idea that employers are not paying wages to young workers, and also one of misclassification, the concept that employers engage in a form of mischief to convince an employee that they aren't entitled to the hourly minimum wage. In examining the law, we're going to focus on how interns can have certain rights restricted, and then examine the other types of workplace law to see what they say about protecting interns. There are three limited statutory exclusions in Ontario that allow for employers to use unpaid interns under certain circumstances. We're going to examine each of these exclusions in depth. The exclusions arise from those who are considered to be an employee under the ESA, and hence be able to access the protections of the Act. So when we're looking at the exclusions, it's very critical to remember that the interns are being placed outside the protections of the ESA. The exclusions are quite powerful, in my opinion. My graduate research focused on employment standards protections for interns, and Ontario probably has the third worst set of laws on the books. Nova Scotia and Manitoba are quite bad on protecting young workers as well. So first we're going to focus on the student exclusion. So if students are completing an academic program that has a requirement relating to an unpaid internship, an unpaid co-op position, a work term, or any other kind of unpaid work, then they don't have to be paid. High school and post-secondary students are excluded from protection of the ESA under subsection 3.5 of the Employment Standards Act. If they're completing a bona fide academic requirement or undertaking a work experience. The bottom line here is that the unpaid labor must relate to an academic degree requirement that is explicit, that is linked to explicit language set out in an academic calendar or explicitly approved by a school board, such as a co-op position. So an example of this I'll return to. Student teachers undertaking a practicum, they don't have to be paid. So I think that's an example that everybody can relate to. Okay, I'm almost done. The next is the training exclusion. The definition of employee under the ESA states that a person receiving training is an employee unless a strict set of criteria are met. The provision under subsection 1.2 of the ESA speaks to persons receiving training and covers unpaid internships. There's a 6-pronged test that lays out the grounds pertaining to under what circumstances a person can be excluded from the protection of the ESA. The test is very strict and has 6 components, all of which must be met if an employer wants to exclude a person from the ESA. The 6 components are: 1, the training must be similar to what is given in a vocational school. 2, the training must benefit the intern. 3, the employer derives little, if any, benefit from the activity of the intern. 4, the intern cannot replace a paid employee. 5, the employer can't